Global happenings today. We communicate. We analyze global news. Stay tuned.
Hello beautiful people, welcome back to our channel. A lot of persons are indeed waiting for the Supreme Court verdict. One of such persons are the very close ally of Wike and Fubara, and it's literally saying that I'm talking about none other person than Honorable Igbini Odafe Emmanuel, who is actually a peace activist and a mutual friend, of course, to both Wike and Fubara. He bared his mind over the issue of the Supreme Court and the laying foundation and what that means. Questions were thrown. I think we're going to give full details on that. Before we do so, kindly subscribe to our channel. They asked him a very simple question. One of such questions was, what's the reaction to the withdrawal of the appeal filed by the legal team of Governor Fubara at the Supreme Court, which many very senior legal practitioners have interpreted differently? He said, I'm not surprised they differ. It is expected to hear such divergent interpretation from respected legal luminaries on very straightforward and unambiguous decision of the Supreme Court, delivered in plain and simple English language. This is the reason sometimes very minor dispute becomes very complex and unresolved once some legal practitioners are invited to handle them. I'm not saying lawyers are not important and should not be invited to help resolve disputes, but it is becoming very disturbing that in some cases the involvement of some lawyers complicate issues. My candid view of the implication of the voluntary withdrawal of this appeal is that they did not challenge or dispute the judgment of the Court of Appeal concerning the relief sought by the plaintiffs and therefore binding on Governor Fubara and all the defendants in the matter. It is settled law, and even the Supreme Court of Nigeria has pronounced several times that any allegation or claim not disputed or challenged by affected party is an admission of same. The major and critical issue in the judgment of the Court of Appeal, now upheld by the Supreme Court, is the affirmation of the legitimacy of Honorable Martin Semohile and the 25 other members of the Rivers State House of Assembly as Speaker and members of the 10th House of Assembly, respectively. This is the bitter truth. The extended implication of this is also that all actions taken so far by Governor Fubara since October 29, 2023 to date that require constitutional approvals of the House under the leadership of Honorable Martin Semohile as Speaker, but which were not presented to the House under his leadership by Fubara, are unconstitutional, null and void until Governor represent them for reconsideration and approval. Now, the argument that the 2024 budget has been spent and therefore can be revisited is not true. Yes, the 2024 budget and approved funds have been spent as claimed by the governor, and that there is even a 2025 budget that has just been approved by a 3-member House of Assembly. But all of this do not invalidate the provision of Section 128 of the 1999 Nigerian Constitution as amended, which gives Rivers State House of Assembly the constitutional power to cause investigation into how funds were expended and demand that all those persons screened, confirmed for appointment do represent themselves to the House led by Honorable Martin Semohile for revalidation to legitimize their appointment. In the civil service, this is done under the process called regularization. This can also be easily done in these cases if only Fubara and Wike would listen to wise counsel from their sincere mutual friends like me for them to meet and resolve their differences. In all honesty, I'm not expecting the Supreme Court to depart from its judgment of February 10th. All other issues around INEC and Rivers State local government election, release of funds to the legislatures and House of Assembly, screening and confirmation of nominees for appointments, and other issues are all peripherals hanging on the main issue. What for me is paramount now is commencing the process of political settlement of Wike and Fubara with judgment of the Supreme Court laying the right and proper foundation to help us do so. Now, but there are people who would disagree with you. They insist that political settlement is completely out of it now, and that only the Supreme Court can resolve the matter. Moreover, there are indications that the Wike's camp is resolved to impeaching Governor Fubara the moment Honorable Martin Semohile returns as Speaker. He now answered, said, first, take it from me that Fubara will remain as governor. He won't be impeached because he committed no constitutional gross misconduct, as at when there was an attempt to impeach him in October 2023. I have said long ago that after this storm is over, Wike will support and lead the campaign for Fubara to be re-elected for a second term because Fubara remains the most trusted confidant of Wike from the senatorial district Fubara hails from. Does anyone think that Wike did not recognize this fact before he went all out to make Fubara a successor, despite the strong and fierce opposition from within his inner political family? The bond between both of them can't be broken even by either or both of them. I know what I'm talking about. It has not been easy for both of them since this minor misunderstanding was hijacked and escalated by those who swore never to allow Wike make Fubara their governor and those who hate Wike for helping Tinubu become president. Secondly, I don't agree with those who rule out political settlement in this matter. Supreme Court has never in history been able to resolve political misunderstandings among leaders of same political party, and this case won't be an exception. Yes, election disputes are easily and completely resolved by Supreme Court, but this is not a case of election dispute. The judgment of the Supreme Court, either way it goes, would only help to lay the foundation for political settlement. Not even the International Court of Justice is able to resolve some dispute between countries, just like what we saw now between other countries of the world. Now, want further to say, for instance, in year 2010, after the painful death of President Yar'Adua, what business had the political leaders of PDP to do with doctrine of necessity when the provision of Section 146, subsection 1 of the 1999 Nigerian Constitution as amended is clear and unambiguous that in such situation, the vice president, being the standby president, automatically takes over as substantive president to serve out the remaining period of the term. But because of the sensitive and delicate political element in the matter, given the fact that there was a gentleman agreement for the rotation of the office of President of Nigeria between the North and the South, which I was part of conversing for, the guarantee equal sense of belonging and to engender national peace, and upon which both Yar'Adua and Jonathan became president and vice president, a political settlement was agreed to. Have we not had dispute between the federal government and state governors that even Supreme Court could not resolve as hard as it tried to until political settlements were adopted? So this case between Fubara and his political oga, as he fondly calls Wike, will not be an exception. I'll show us, and I would lead it. Who would you blame for this crisis in Rivers State House of Assembly, which sees the governor recognizing and relating with only 4 or is it 3 members of the House of Assembly? This is what he answered. I place the blame squarely on former President Buhari, APC governors, the leadership of the 9th National Assembly, and the then national leadership of APC in year 2019 for failing and refusing to take over the legislative function of Edo State House of Assembly by invoking Section 11, subsection 4 of the Nigerian Constitution. Immediately, former Governor Godwin Obaseki deliberately shut out 14 elected members of Edo State House of Assembly out of a total of 24 elected members because they are loyal to former Governor Adams Oshiomhole, whom was his political leader before they both had their disagreement. They knew that the action of Obaseki was a threat to our constitutional democracy and the secretion of the Nigerian Constitution, which must not be allowed. But they chose not to take action because many of the APC leaders who were not happy with Adams Oshiomhole when he was the national chairman of APC felt it was time to destroy his political base in Edo State and weaken his influence at the APC national level. If not, how does one explain a situation where Obaseki demolishes part of Edo State House of Assembly complex and relocated a few members loyal to him to an office in a government house from where he directed them to do as he likes? Loyal to him to an office in the government house from where he directed them to do as he likes. If he was stopped then by President Buhari and the 9th National Assembly, my dear brother, Governor Fubara would not have contemplated replicating same in Rivers State, no matter any passive provocation from the members of Rivers State House of Assembly. When this was happening then Edo State, I kept calling on President Buhari and the leadership of the National Assembly to take over the legislative functions of Edo State in order to stop such uncivilized and undemocratic action of Obaseki and to have the 14 members back to the House of Assembly. I had to place full-page adverts in some national newspapers, grant several interviews to the media, and flew to Abuja from my base in Warri. For the same reason, all that mattered then in APC was to destroy the political base and influence of Adams Oshiomhole. But there are allegations making rounds now that when Wike was governor, he also presented 2016 budget to only 7 members of Rivers State House of Assembly, and therefore he has no moral authority to oppose Fubara for doing the same now. He now answered, he said this is not correct at all. Wike never at any time presented 2016 appropriation bill to a 6 or 7 member Rivers State House of Assembly. It is on record that there was never a time between May 2019, May 29, 2015 and December 22, 2015 that the Rivers State House of Assembly had fewer than 25 members constitutionally recognized. An overwhelming number of them were PDP members and loyal to Wike. I challenge anybody to a public debate on this. The unfortunate case we have here today under Fubara is that only 3 legislators out of 31 members assembly claiming to constitute State House of Assembly and in position to carry out legislative functions of the state. Few days ago, a former commissioner of information under Wike, who belonged in the same WhatsApp group with me, made some allegation against Wike, claiming that Wike presented 2016 budget proposal before only 6 members of Rivers State House of Assembly, and that his own screening and confirmation as commissioner was also by these same 6 members. When I asked him to mention the date, time, and names of the 6 members, he declined. And he, according to him, said, I will have over 100 more questions to ask him. One of the follow-up questions I wanted to ask him is the reason he accepted to appear before such alleged few numbers of members for confirmation, but only comes now that he is out of government, to condemn that alleged process he benefited from. Let me state the facts in order to set the record straight and correct this falsehood. First, the Rivers State House of Assembly has 31 members, declared elected by INEC following the April 2015 House of Assembly election, with PDP having overwhelming majority of them, and therefore had the presiding and principal officers, except for a few positions reserved for minority parties. On October 26, 2015 or thereabout, the election tribunal sitting at Abuja annulled the election of the then Speaker of the House of Assembly of some others who are PDP. As expected, they filed an appeal at the Court of Appeal against the decision of the tribunal, which meant that they remained legitimate members of the House until Court of Appeal decides on their appeals. The Court of Appeal did not deliver judgment on their appeals until December 23, 2015 and ordered a rerun in all the affected constituency, which was finally conducted and concluded on December 10, 2016. Now, carefully listen to this critical information I want to give. Governor Wike presented a 307 billion 2016 appropriation bill tagged budget of consolidation to the Rivers State House of Assembly. But is this the case today? Some reported that there were few members physically present in the hollow chamber when Wike read his speech and presented the appropriation bill. But that immediately after, the other members rushed to join the ongoing proceeding without any objection. What is instructive for me to state here is that physical presence of members in chamber at any time during deliberation does not constitute the total members or numbers of members of the assembly and cannot therefore invalidate the business of the day. We see sometimes at the National Assembly where plenary is on with only few members cited and later others begin to arrive to join them. Some come in to sign the attendance register and thereafter excuse themselves to attend to other legislative assignments in their committees or offices, or to attend to very pressing personal issues. The letter and spirit of Section 91 of the 1999 Constitution, Nigerian Constitution as amended, which deals with the composition of a House of Assembly, is what is at stake concerning 4 and now 3 members claiming to compose Rivers State House of Assembly. This section of the Constitution states clearly that there must be a minimum of 24 elected members to constitute a State House of Assembly. Section 96 of this Constitution went further to say that quorum should be at least 1/3 of the total elected members signed to participate in legislative business of the day. Rivers State House of Assembly of 31 members must therefore at all times have at least 11 members signing to participate. The 11 of them don't need to be physically cited at the same time in the chamber as stated in the case of National Assembly. What is important is that there is a legitimate elected speaker or a deputy speaker presiding, where the APC legislators present during the project presentation by Wike. If yes, how many of them? If no, why were they absent? Lastly, let me remind Nigerians that in year 2019, PDP senators led by Senator Godswill Akpabio staged a walkout from the Senate chamber while screening for confirmation of Rotimi Amechi as minister was on. Did their walkout in protest invalidate the screening and confirmation of Amechi as minister? No, because the Senate had the minimum number of senators constitutionally required. My colleague is in the house. What's your take in what he just said now? Remember, don't forget that he's a good friend to both Fubara and Wike.
Well, I would say that he doesn't really have much info about what is going on in Rivers State. Sorry to put it that way. Number one, he said that there will be reconciliation. There can never be reconciliation because already there was an in-house meeting when Senator Mbibi was being given that flag of that anointing to be Wike's candidate come 2027. So if he says Fubara is the only person he can trust, how about Mbibi now? Mbigi. So that clearly shows that he doesn't even know what is going on. And even on the issue of presentation of budget to 6 man, this thing, it was clearly pointed out there. It was seen. But the commissioners have come out to affirm it. It wasn't that those guys they just wanted to stay away from it. They were not allowed in. So it's not something that we debate about. From all indication, it has a very hollow hollow knowledge of what is going on, or he has also decided to take side with Wike, because if you listen very well to all that he had said, everything points to Wike, everything, and putting Wike right. So for me, let's just put our fingers together and watch to see what will come out during the Supreme Court verdict.
What do you think about what he said about the standpoint of Supreme Court eventually?
Well, no one can predict it. That's the truth. No one can predict how it's going to go. Well, now, no matter what the Supreme Court will do, they'll align with the Constitution and look at the situation on ground. So for me, it's best we just sit back.